Hello and Namaste. I am Ketan from 192 Consulting. We have been posting these videos for past more than 40 weeks now. The primary intention of posting these videos were to interact with the investors and with our clients and solve their problems relating to investments and reclaiming of their investments. Over a period, we have gathered a considerable support about these videos, and a lot of investors are reaching out to us with their questions. So, starting from this video, we are actually going to answer the questions which were either on these videos or have been sent to us through emails. I'll be taking 2 questions per video in this series of question and answers containing 10 total videos. So I'll start with the first question, which is right in front of me. One of our investors has asked, what if the names on the company's records and succession certificates don't match? Okay, so there are two things to this. The names on the succession certificate and the company's records, if they are mismatching, then it is the nodal officer's duty to take a viewpoint on this. The nodal officers generally put it to the RTAs because RTAs are SEBI approved agencies who actually look into the matters related to shares. Now, if the names are not matching, then before applying for the succession certificate, it is imperative that the investors should get in touch with the RTA and get the exact name of the investor on the records of the company or the RTA. And if the names on the succession certificate and the company's record are mismatching, then two things can be done. First of all, if the nodal officer or the RTA allows, then a document issued by the central government or state government containing both the names or containing the names as in a separate documents containing the name of the investor on the succession certificate and containing the name of the same investor on the company's record should be provided. That is one thing that can be done. Or secondly, a revision application can be made or an application can be made to revise the succession certificate, but that will again entail the legal process. So these two things can be done. Either if the RTA and the nodal officer allows, then submit two separate documents. One containing the name on the company's records of the same person, and the other document which on which the name matches with the succession certificate. That is one thing if the RTAs allow so. But if the RTA takes a viewpoint that the name should be same as on the company's records, then a revision application to be made to the court giving all the facts and again endure the same legal procedure and get the succession certificate revised. So these two things can be done in case of the names are not matching on the succession certificate and on the company's records. Next question that has come in front of me is, shares are in single name but there are multiple legal heirs. Then is it mandatory to obtain certificate in the names of all legal heirs? To answer this question, let me first reflect on what is succession certificate. So succession certificate is the document or the order issued by the court which actually entitles a person or establishes the fact that the person or all the legal heirs are the successors to the assets of the deceased person. Now, if there are multiple legal heirs, in the first place, the answer is yes, succession certificate has to be taken in the names of all legal heirs. But if the legal heirs agree to obtain the certificate in the name of one legal heir, if all the legal heirs agree that succession certificate be obtained in the name of one particular legal heir and they have no objections, then they have to testify in front of the court, and then the court will issue the succession certificate in the name of the one legal heir, and then he can be the claimant on the shares. This is possible only with the succession certificate, because if they apply for legal heirship certificate, then the court will not allow this plea. The court will say that the legal heirship certificate will be issued in the names of all legal heirs only. So that is one thing. Succession certificate can be obtained in the name of all legal heirs or a particular legal heir if others are not objecting to it. And secondly, if the legal heirship certificate has been applied for, then it will be issued compulsorily to all the legal heirs of the deceased person. So these were the first two questions that we answered in this video. So if you have any queries related to investments or reclaiming of your investments, you can feel free to ask us. You may reach out to us on info@192.in or simply mark your comments on this video. We will be all the more happy to help. Thank you so much.